well, let's get started. Other people will be trickling in as we go on, but we can get started. So my name's Mark Mancini, and I'm the National Director of the Running Meat Society. We are just really pleased today to be offering this webinar about an issue that deserves much more attention and one that's really important to the rule of law, and its feasibility in Canada. And that's the issue of COVID in the prisons. And to help us navigate that issue, we have today Professor Debra Parks from the Allard School of Law at the University of British Columbia. So I'm going to introduce Professor Parks, and then we'll jump right in. So Professor Parks joined the Allard School of Law in July 2016. Her scholarly work examines the challenges and possibilities of addressing social injustices through rights claims, with a focus on the criminal justice, corrections, and workplace contexts. For example, with funding from SSHRC, Professor Parks has examined mechanisms for oversight and accountability of imprisonment in Canada. Since beginning her academic career, she worked as a law clerk to justices of the BC Supreme Court and practiced with the litigation group at Gowlings in Toronto. She maintains strong connections with the bench and bar, welcoming opportunities to present at judicial education conferences and at continuing professional development workshops for the practicing bar. So we have somebody here with just a stellar resume, somebody who is dealing with these topics on a daily basis. And so thank you, Professor Parks, for taking the time to talk about this important issue with us. And I'll turn things over to you. Thank you again.
Well, good morning, everyone. Yeah, I'm out in British Columbia, so it's morning here, and I know that it's sort of lunchtime for those of you in Central Canada and anyone from the on the East Coast. I can see some of the thumbnails and names of folks who are joining, and certainly I recognize a number of names of people who actually work around these issues and have a lot of knowledge and experience. So, you know, I'm just one of those people who wants to contribute to us thinking around what it means to address something like the COVID-19 coronavirus pandemic in our society, and particularly in correctional institutions, in prisons, and thinking about what that means for those of us who are legally trained and either students or lawyers or working with law as teachers and researchers, as I do. So I want to thank the Running Meat Society and Mark in particular for reaching out and inviting me to do this. It's my first time doing one of these, and in fact it's my first time doing really an online lecture like this, other than for my poor students who've been subjected to my fumbling in March, and then hopefully a little bit more adept efforts at online teaching in the fall. I am teaching prison law, or penal policy it's called, at UBC in the fall, which I'm quite excited about, and it will be in this kind of environment as well as using other kinds of online. I'm going to try to share my screen here for a second, and you know, these things are always fraught. Okay. Yeah, I just have a couple of, or actually a small number of slides. I'm not going to be trying to deal with slides throughout my talk, but I have a few that just kind of point to a few key things I want to talk about. I'll just also acknowledge as I get going that I am here, I'm in New Westminster, British Columbia, located on the traditional, ancestral, and unceded territory of the Coast Salish peoples, particularly the Kakite First Nations. First Nation is the nation here, and I acknowledge that and direct my thoughts to that at the outset of my talk, because the impact of colonization is felt every day in our society, but really fundamentally in Canada's prisons and jails and other places of detention. In terms of the if you walk into those places, certainly on the prairies where I lived for 15 years, but really anywhere in Canada, you're going to see many Indigenous people. And so I think you want to think about what reconciliation means, what the rule of law means in that context as well. So I'm turning my attention there. I'll also say just a little bit about my approach. And, I always think it's useful to situate oneself in terms of the approach one takes to issues. This is a quote that I kind of like, and I have it actually on my door. And it may not speak to everyone, but it speaks to me in terms of what the law, how I think about the law. And for me, this quote from Mari Matsuda, who's a law professor in the US, says, "There are times to stand outside the courtroom door and say, this procedure is a farce, the legal system is corrupt, justice will never prevail in this land as long as privilege runs in the courtroom. And there are times to stand in the courtroom and say, this is a nation of laws, laws recognizing fundamental values of rights, equality, and personhood. And sometimes, as Angela Davis did, there is a need to make both speeches in one day." And for me, that kind of sums up or encapsulates a lot of how I approach thinking about the law in this area, and really about the law more generally. That I do, I do come at it from a position of questioning and critique about the impact of the laws that we have. And I like to try to look at what the evidence shows us about how laws are actually functioning, and whether we can say, whether we're satisfied, and whether we can say that justice is actually being done under our laws. And I think this moment is one where we're doing a lot of that. Some of us are doing a lot of that reckoning, I think, in thinking about the COVID pandemic, as well as the Black Lives Matter uprising and other kind of societal events that I think are focusing on questions of justice and equality and the law. And so this is just a slide by way of overview of kind of what I'm going to be talking about today. And I want to leave plenty of time for Q&A. So Mark, please do cut me off at 8 or 9:40, I guess, and make sure that we do have that time. I'm going to try to keep track of time myself, but I'm asking you to do that and welcome that. I don't want to be one of those people who just kind of blathers on and then doesn't leave time for engagement. So this is kind of an outline of what I'm going to talk about: the problem of COVID-19 in places of detention, some of the calls for depopulation through the release of prisoners, what are some of the legal grounds for seeking release or other remedies, what have been some of the correctional responses, what a little bit of thought about what the future might hold, a little bit of trying to think about what even over the short term and potentially longer term, and then for reflections on these events and the rule of law in prison. It's something that Mark invited me to reflect on. Okay, so let me just stop sharing there for a moment and say, I don't know that I need to say too much. I don't want to spend too much time on the problem of COVID in prisons. I mean, there has been a fair bit in the news media about this, but it may not be entirely familiar to everyone. But basically the issues are that the incarcerated population is particularly vulnerable, maybe certainly more than I would say the general population, to the spread of coronavirus. People in Canada's prisons and jails are especially likely to have infectious diseases such as hepatitis C and HIV. Here I'm actually drawing on a letter that was written signed by over 100 doctors, nurses, and other health providers in Canada, urgently calling for the depopulation of prisons in light of the pandemic. It was in early April. The 25% of the population of federal prisons is over 50, and people in prison are generally understood to have worse health outcomes and health attainment than the general population, and respiratory diseases, diabetes, tuberculosis, asthma are all overrepresented among the prison population. There are issues with drug use and safe supply, and that COVID might increase the risk of opioid overdose death, both in places of detention. Obviously, we've seen that in the community as well. And then secondly, the prison environment heightens the risk for transmission for both prisoners and staff. Conditions can be crowded. Prisoners lack the ability for social distancing or physical distancing, as we are becoming very familiar with in the community. This is certainly true for those who share cells, and there are still some places of detention where people are double bunked or sharing cells. But even for those who are single bunked, they're frisked and handcuffed by officers. They line up for medications. They share common spaces in some cases, such as dining halls, use common telephones, bathrooms, showers, etc. And prisons have lacked us. And again, I should say, when I talk about prisons, I'm often talking about federal prisons. Later, when I talk about some of the legal mechanisms, I'll be talking about federal prisons. And just a reminder that there you're talking about people serving 2 years or more in a federal penitentiary, but also of the more than 40,000 people on a given day who are incarcerated, the vast majority are actually in provincial places of detention, remand centers, or sentenced, but serving less than 2 years or time on remand. And so obviously there's different conditions in across those jurisdictions, but there are some sort of common issues that we see arising. Conditions such as lockdowns, which have been some of the responses, can actually increase human contact in some cases, since multiple officers are required to transport prisoners around the institution and that sort of thing. Okay, so I mean, there's lots we could say about that, but let's just sort of think about that context. The prison as a place where people are vulnerable to infection. There's staff going in and out of prisons every day to their homes, and so there's issues with the spread to the community. And obviously, then there's prisoners coming in and out as well. So we've seen that in the initial response to the outbreak and the pandemic declaration. In late March, the Correctional Service of Canada, which governs the federal prisons, made a number of key changes. The immediate suspension of all visits, the suspension of all transfers, with the exception of those made on the basis of emergency, closure of prison gyms, libraries, and other communal spaces, suspensions of temporary absences, with the exception of medical, suspension of programming, suspension of communal serving and eating where feasible. And then there were modified routine plans implemented where prisoners would be locked in their cells for significant periods. I mean, this varied, and then there's also different routines that were instituted where you did have an outbreak in an institution. But what the correctional investigator, who's the federal prison ombudsperson, has documented is the extent to which there were significant significant times of people being locked in their cells with no access to the outside, or out of cell for even some days, and certainly when they did 30 minutes twice per week, for example, in some cases where there was a modified routine instituted. So the correctional investigator has detailed a number of instructions also given to staff that, for example, non-essential staff were working from home or have been working from home. And crucially, this means institutional parole officers who are charged with facilitating, and others who are charged with facilitating preparation for release. So that's been certainly an issue that I've seen talking to prison lawyers about advocating for release plans and that sort of thing, that like all of us, like here I am in my family room, some correctional officers are working at home too and trying to get their work done in an environment that, for some of us is a bit chaotic. I have young children who happen to be away at the moment, and I'm hoping I won't be interrupted, but you can imagine how that can have an impact on productivity and ability to do the work. Other things that were changes: movement on and between various units has been restricted, community contact very significantly minimized, elders and chaplains not on site. There's a number of different responses. What have we seen in terms of the rate of infection? I'll talk again here about the federal context, because we have some pretty good data on that. And Correctional Service of Canada has, for a number of months now, been posting on their website, basically daily or every couple of days, an update on testing and rates of infection in the institution. So that's actually really good to see. Criminologist Anthony Dube wrote a submission to Minister Blair in late April, and he had crunched the numbers that were publicly available at the time, and he identified that the rate of COVID-19 infection in federal prisons was 13 times greater than in the general population. Alarmingly, he noted that women, incarcerated women, the infection rate for them is 77 times the rate for women in the community. And I'll talk about those numbers in a minute. So what you see is, as of this week, CSC has reported that 300 incarcerated people have tested positive for COVID-19. 2 have died. There have been 1,144 negative tests. So the vast majority are still untested. In Mission Institution out here in British Columbia, there have been 120 prisoners tested positive. Federal Training Center in Quebec, 162. Port Cartier in Quebec, 15. Joliet, which is a women's prison, 54 out of 80 prisoners in late April tested positive. Also 31 correctional staff at that time. Grand Valley in Ontario, 8 women prisoners. So when you know that women are only 5% of the federal prison population, or somewhere around that, and maybe it's a little bit higher than that right now, but it's under 10. I haven't looked lately. They are vastly overrepresented among those who've been infected. And so that's a 77 times the rate of infection of women in the community. Okay, so what have been some of the responses? Well, certainly many prison lawyers, advocates, John Howard Society, Elizabeth Fry Society, other groups that advocate for people in conflict with the criminal legal system and incarcerated. Many have called, and I certainly was one of the people who was calling for depopulation and the release, a coordinated release of prisoners to address the pandemic and to try to limit the spread in in congregate living facilities like this. So in March, when the pandemic broke out, there were approximately a little over 14,000 people in federal prisons. At the same time, there was over 9,000 being supervised in the community on parole who are under federal supervision. We know that Indigenous people are much more likely than non-Indigenous people to be incarcerated longer before attaining parole. So the percentage of the incarcerated population that is Indigenous is even higher than those who are on parole. Of the 14,000, a little over 3,000, or 24%, were classified as minimum security at this time in March. Also, it's worth noting that every year, approximately 4,200 people in the last few years have been released at 2/3 of their federal sentence or statutory release. And this is a presumptive release. Obviously, you can be detained as well for reasons of public safety. But this is where Anthony Dube, again, a criminologist, has kind of crunched some numbers, and he has noted that, for example, even if those releases were sped up by a few months, there would be relatively minimal impact on public safety. First of all, these are people that are being released anyway, and people on conditional release are relatively unlikely to have their parole revoked for violent offenses. People do have their parole revoked, but it is generally for violations of conditions. Less of people released on parole, less than 1% are readmitted for violent offenses. Now, obviously, the stat release population, there are people who haven't yet got parole, so those numbers may be a little bit different, but it's worth thinking about whether there could have, should have been, and can still be more efforts to coordinate releases. What we've seen is instead very piecemeal and limited releases. I'll talk in a minute about the potential for use of temporary absences, which again, the data shows are successfully completed 98.8% of the time. So there are provisions within federal law for releases. Despite the stated intention of the public safety minister to collaborate with the parole board and to facilitate releases, we generally haven't seen a significant coordinated effort. And what we have seen, I mean, you may have seen recent numbers that have been released just this week about a decrease in the overall prison population by some 6,000 across Canada, and that's including provincial, territorial, and federal. But that has not been through any coordinated release. If you think about it, the number of people in prison is lower for a whole range of reasons. One being that people aren't going to trial, and people aren't being sentenced to federal prison, or haven't been, right? Like courts are getting back, but there was a significant period of time there. And so there's lots of, reasons why we have a reduction. Ivan Zinger, the correctional investigator, has written that he does not see any evidence that the reductions are through a significant effort to coordinate releases. Warrants of committal are down very significantly, undoubtedly as a result of the courts not sitting, and revocations are also down. So there's fewer people being revoked and coming back into federal prison for those reasons. And then provincially, and sometimes talk a bit about that, because we always talk about the federal prisons, but I think it's important to also talk about provincial and territorial incarceration, and I often do in my work. We have seen some different things. And certainly some provinces, through efforts of sometimes from within the Ministry of Justice there, or the Attorney General's branch, or whatever it's called, Northwest Territories, for example, made some significant efforts and documented their efforts and are reportedly continually assessing their population. It's a small population, obviously, but and have facilitated very substantial releases. Nova Scotia is also an interesting example, where, and according to the recent statistics that I've seen, had the most significant reduction in their provincial incarceration, which was 41%. And that was due to a whole range of things. But one of the really interesting things that we saw in Nova Scotia was some real coordinated efforts between lawyers, so defense lawyers, Crown attorneys, community groups like Elizabeth Fry Society, John Howard, halfway houses, different, not even halfway houses so much as other community organizations that could support people in the community. There was some funding that was able to be allocated on a short-term basis for people released to be in hotels with some support and supervision. So there was an interesting kind of mobilization that we saw in Nova Scotia that we didn't see on that scale, or I didn't see on that scale anywhere else, and it actually had significant results through those efforts. I think the judges were also very open to that in Nova Scotia, I think through the chief judge and some others. So it's very interesting to see that you can have some different results. I'll just share my screen one more time here to say that I'm going to talk now just about some of the legal mechanisms for release or other remedies, and just to kind of run through those. So for those who are thinking about, okay, what are the bases? I mean, I've hinted at some of them and maybe talked a little bit obliquely about some, but what are the different ways that that one might have be able to seek release or some other remedy for someone who's incarcerated? And what are those tools? What are those legal tools? Well, I'll talk about bail, sentencing, talk about temporary absences, parole by exception. Some of these I'll hit on very briefly. What's called the Royal Prerogative of Mercy, not very well known. the potential for charter challenges, class actions, judicial review in the federal court, habeas corpus in the superior court, and human rights complaints. So yeah, I mean, there's a few criminal lawyers here I recognize on the call or on this talk, so who are very familiar with what's been going on, probably with respect to bail. Obviously there's decisions that, I mean, bail is a discretionary decision. There are the different grounds for seeking bail of someone pending trial. But what we know from the case law is that COVID judges are taking judicial notice of the COVID-19 pandemic and its impact on places of detention, particularly pretrial places of detention. It is a material change in circumstance that has justified bail review and review of an earlier denial of bail. And it is relevant to the tertiary ground of the assessment of the public perception of the administration of justice. And obviously there's decisions that go in a variety of different directions on that, and there's a whole body of case law that's developed. But there has been some recognition there. With respect to sentence reduction, here again, we're talking about COVID and the pandemic and its impact on places of pretrial detention, and so certainly, there have been a number of decisions in which I think defense counsel are often making submissions about getting enhanced credit for the conditions in places of pretrial detention. And some judges are receptive to that, but obviously, again, it's just one factor that goes into assessing the fit sentence, and even whether that you would have enhanced credit. But certainly, the key is to, in most of those cases, is to show, in particular, that your client might be particularly affected by the COVID-19 pandemic due to medical issues or health issues, and also what is the evidence of in the particular place of detention. I've seen a lot of cases around Toronto South Detention Centre. There are others about the conditions in Manitoba, Remand Centre, and various places. I won't say too much about that, but about other forms of release. Well, talking about federally sentenced people in federal prisons, one of the more promising developments, at least, or it was hoped to be promising, was the Snow decision, which came out of, I see Lisa Kerr here, came out of the Queen's Prison Law Clinic, and Paul Quick, and then Paul Champ as co-counsel from Ottawa. And this was something that I was actually, I talked with the Pauls before the case went, before they filed their action. But basically, under the Corrections and Conditional Release Act, there is provisions for the parole board to authorize unescorted temporary absences, and they can be for medical reasons. There's a whole range of uses for unescorted temporary absences, but one of them is under subsection B of section 116(1) of the CCRA is for medical, and normally that's to go to a hospital for treatment or that sort of thing, right, or to some kind of treatment in the community. But it was argued in the materials that were filed, and really we would have hoped not to have to go to court on this, and it was resolved on the eve of the hearing. But there is provision and ability for corrections, because actually section 21 of the parole board policy manual delegates to the warden, the institutional head, the power to grant unescorted temporary absences, except for certain incarcerated people, such as lifers and that sort of thing. But they have to first go to the parole board, at least for the first one. But in any event, this could have been used more significantly where the person has a significant medical risk in the community. Mr. Snow presented, I think, quite a compelling case as someone who had, quite significant health issues, lung issues, COPD, a particular kind of cancer, supportive sister in the community. He'd been a long-term prisoner who could be released safely into the community. In any event, it was still resisted by corrections, and it was only with the filing of the action in federal court, and then on the eve of that, the UTA was actually granted, and Mr. Snow was able to go to his sister's basement apartment where he could self-isolate. And so, but then what we haven't seen is very much significant uptake on that. And again, it took going to court to kind of compel that, which I'll come back to in a minute. Okay. Oh, lost track. Sorry here. Hang on. Okay. Yes. I guess the other thing to talk about around parole is the ability to expedite parole hearings and to identify, within the prison population who could be expedited for parole. And this is, again, something we didn't see at a systemic level. And so, that I think was a real missed opportunity, has been a missed opportunity. And when I talk in a minute about the future, I think we want to look at potential for second wave and further, how we're going to handle things going forward, and have we settled into this, the current approach. I hope not. Parole by exception is again, another possibility. Many advocates have suggested that this is something that should be used. The CCRA section 121 is I don't suggest is widely used. In fact, it is not widely used. It has been very underutilized historically, and there has been a little bit of uptake in this time. The stats I saw recently was that there were 11 parole by exception cases granted from March to I think it was July or August, and that's twice what was granted in all of last year. It's still a drop in the bucket for the federal prison population, but there has been a little bit of uptake there. I could talk about delays in seeking parole. Royal prerogative mercy, we can take up in the questions if people are interested. I do want to just say a little bit about charter challenges and class actions, because we have seen in the last couple of months, some fairly broad-based claims being launched. The Canadian Civil Liberties Association and other groups have launched and there's also individual litigants in that case, have launched a charter challenge to the well, it's a judicial review in federal court, but it's for mandamus, the enforcement of provisions of the CCRA, but also for declarations that rights are being violated, sections 7, 9, 12, 15, with respect to the correctional services handling of the pandemic and failure to take proactive steps to ensure prisoners' safety. And so that's an interesting case that has been filed, and obviously it will take time. It's not something that we're going to be able to see, and I'm happy to talk about that in questions and what we think about the likelihood of success on a case like that. There have been also some class actions, and that's something relatively new. I've been studying prison law for 20 years now, and really the use of class actions has been in the last 5 years, really, and in any significant way. And there are certainly some lawyers who developed significant expertise doing this and are focusing on that. So we now have a class action suit filed on behalf of incarcerated people at Mission, where there was the significant outbreak. It's been filed in Vancouver. In this claim, the prisoners argue that their rights were violated under 7 and 12 of the Charter because of the lockdown conditions they were subjected to. There's a range of other claims and relief in there, but they were under total lockdown for a week starting on April 2nd and not allowed to exit their cells for any reason. Since then, they've been allowed out of their cells for approximately 20 minutes per day as of when the suit was filed. And there are 2 subclasses there, one for incarcerated people who've tested positive, and one for those who are just subject to the harsh lockdown who were not tested positive. There's been another class action filed, maybe others, at least, or others maybe know of things I'm not aware of, but I'm aware of at least one other, which is in on behalf of women incarcerated at Joliet in Quebec, again, where there was a very substantial outbreak of the pandemic, and really significant impact on the incarcerated people and, of course, staff there as well. And I haven't really talked about that yet, but that's obviously a huge piece of all of this, is thinking about the impact of COVID with respect to staff, and how do we think about that in the context of these legal cases and remedies. So there's the class actions. I'll just mention habeas corpus because I always am keen to talk about habeas corpus. It's thinking about the rule of law and Runnymede Society and the way that habeas corpus has been part of our law for hundreds of years and is about ensuring that detention is lawful and that deprivations of liberty are lawful. And we haven't seen much in the way of habeas corpus, at least ones that I'm aware of, being used as a means to seek release in the context of COVID. I've seen a couple of cases. There was a recent case where prisoners were successful in Nova Scotia on a habeas corpus motion to be released from segregation. And part of it was they were in pretrial detention, and due to the COVID impact of COVID on their trials were going to be delayed, and they were being held in segregation indefinitely with no prospect of being released. And so that's the only case I've seen where habeas has been used, but it could potentially be utilized more. Obviously, there you always have the 2 requirements of a deprivation of liberty and then a finding that it's unlawful. And so there may be some more uptake there, but because often you're talking about conditions that you're in, and there hasn't necessarily been you haven't been transferred to segregation. Maybe if you're just in conditions that are harsh and potentially threatening to your health, there's an open question whether that would meet the threshold for deprivation of liberty. Human rights complaints I just want to mention because I see I'm at time, Mark. Yeah. So let me just say that I think there is a possibility for human rights complaints. Prison lawyers have been using human rights processes to address discrimination on the basis of disability in particular for some time now. And Prisoners Legal Services, for example, out here has a number of times used human rights complaints, potentially on the ground of disability for if you could make a case that there's a discriminatory impact on people with certain disabilities, you may be able to use human rights. But again, what your remedies are going to be different and limited. Just a couple of things by way of conclusion then about what this means for lawyers and law students thinking about the rule of law. Well, the Sauvé decision, which is one that's always been dear to my heart and one that I have written about quite a bit in the early part of my career, prisoner voting rights case where the Supreme Court declared that prisoners are not temporary outcasts from our system of rights and democracy. My colleague, Efrat Arbel, has written a really compelling piece, if anyone's interested, in the Canadian Journal of Human Rights on how the Sauvé decision embodies a normative rule for that has implications in how we think about the rule of law in places of detention. There is certainly, I think, a need to appeal to law and to the rule of law in the context of advocating for incarcerated people. But the law in this context does not enforce itself. And we can see that decarceration is possible from even some of the examples that we've seen here and in other jurisdictions. But legal and often litigation pressure is crucial to actually pushing that. And we've seen this for some time now, I think. The Snow case is obviously an example, but I also think it's useful for lawyers to think about how they might work in the context of their court cases, but also coordinating with other community groups like we saw in Nova Scotia for the kind of more coordinated efforts to seek release. I always have lots that I could say, but I want to stop there and open it up for discussion, questions. I'd love to hear from people here with your thoughts about what you're seeing or what you're concerned about in relation to what's going on or what I've said. Questions for me. Welcome all of it.
Okay, well, thank you so much, Professor Parks. That was very insightful. Let's see. So you can ask questions via video by raising your hand using the raise hand feature, or you can type them into the chat box and I will moderate them accordingly. So does anyone have any questions? I see a hand up from Chris.
Hi there. I'm a defense lawyer in Toronto. Thank you very much, Professor Parks, for your great talk. My question is about how appellate courts are treating these conditions in sentence appeals. I don't know what other appellate courts are doing, but the Ontario Court of Appeal has sort of repeatedly said that, absent an independent ground of like an error of law that does nothing to do with COVID, we're not going to do anything. And the conditions of incarceration are a question for the parole board, and we're not going to take that up. So I'm wondering if you've seen that other appellate courts are mirroring that approach, or if someone's done something different. I think I've heard this already, but I'm wondering if you can confirm that the parole board really has not taken up the COVID question.
Yeah, well, so first, thanks, Chris. I certainly know your name from, I think, Twitter and seeing the work that you've been doing. First, I don't know if she's actually on the call still, but I'm remiss for not at the outset thanking my research assistant, Lily Dubrovsky, who did some research for me in advance of this talk. Lily, if you're there, shout out. And even if she's not, I want to recognize her. So she did a little bit of digging for me, and we couldn't find, she couldn't find any appellate courts that were doing anything radically different from that, the Ontario case of, is that Casman, or I can't remember which one that one, but it's unfortunately, it would be nice to see more there, but generally that's kind of consistent with appellate approach to sentencing, although then you see cases where in a whole range of contexts, appellate judges will interfere with sentences, and but yeah, it's not seen as an independent basis for appealing a sentence and reconsidering it, right, absent the normal considerations for appellate deference. Yeah. And then the parole board. So, I mean, certainly it's not that the parole board has done nothing. Like, again, they're under a lot of constraints too. Parole board members are working at home. There's all those issues. There have been some attempts to expedite some hearings, and I've heard, I'm on a prison lawyers listserv where there's some discussion about maybe getting some hearings expedited. There was a few where that was able to happen, but for the most part, it has not again been a coordinated response. Unless someone's seen something different, I have not seen that, and that's unfortunate, I think, because there are, again, if we think about just the numbers of people in federal prison who are going to be released in a few months anyway, like the idea that we wouldn't do something at a systematic level between CSC and the parole board to coordinate that is kind of beyond me why that hasn't happened. I mean, obviously everybody's very stretched, and the pandemic has put pressure in all kinds of ways, so we acknowledge that. But we're talking about very serious rights as well as bodily safety. Looking ahead to the parole issues, I think is worth thinking about too, because the other thing that's happening, and I'm hearing from lawyers, is that and advocates, is that people who are coming up for eligibility for parole or are already eligible are not going to be able to get parole because they haven't been getting the programs that they need. They haven't been able to meet their fulfill their correctional plan, and that's how you satisfy the parole board that you can be released, right? And so it has a knock-on effect, right, with all of the cancellations of the temporary absences, showing that you can go out in the community safely, completing the programs, and then not being able to. I mean, Ivan Zinger has done research before he was the correctional investigator to show that if you don't have Correctional Service of Canada support for your parole application, you are extremely unlikely to get parole. Right? It was like less than, I think it was 5% of cases would you ever get parole if you didn't have CSC saying we support this application. Right? And so without that, we're going to have another, I think, backlog of people detained longer.
Okay. Any other questions?
I see Matt Strauss.
Oh, Matt. Yes, go ahead.
Hi. So I'm not a lawyer, so if this is an ignorant question, please forgive me. I'm a physician in Kingston, Ontario. So prison was a large part of my practice, although I'm not a prison physician. You made a convincing case early in the first half of your presentation about how prison is an unhealthy place, and that unhealthfulness could be a violation of rights. But is there a more general case that leaving prison is healthful? So, like, is it the prison that is correlated with unhealthfulness, or is it criminality and other lifestyle issues? Is there a more general case to be made? Like, I understand the Snow case where he had a more healthful place to be. That's much stronger. So how would that affect kind of class action considerations?
Yeah, no, it's a really good question, because I mean, I guess what I was talking about there was just the way that the pandemic is particularly threatening to people, to a lot of incarcerated people because of their the health issues that they have. But you're absolutely right that I mean, incarcerated people aren't like a discrete group of people, criminals, and that's why I don't use the language of offenders or criminals, because they're community members who are who bear a lot of resemblance to other community members who are on the outside, particularly with respect to marginalization and issues of health, of substance use, of poverty, and all the things that are correlated with lower health. What your question gets at to me also is thinking about all this, yes, it's fine and good for lawyers and law professors to call for people's release, but release to what and where, right? And so that, I mean, I'm very alive to those issues. And what was interesting to see in, for example, again, it was somewhat small scale. Nova Scotia is not a huge province, but there was actually some really interesting concerted effort in the Nova Scotia advocacy around releases. They had an organization that's nurse practitioners and doctors involved in the coming up with sort of plans and release plans for the folks that they were seeking release for. These were all people who were either awaiting trial or were provincially sentenced. So we're talking here not about federally sentenced people in that case. We're talking about people that are part of this large group of people, and you may see them, as you said, in your practice, who are in and out of institutions, right? And who have these health issues. So I think for this to work, we do have to have meaningful investment in community supports, right? Like that is the case. I mean, certainly incarceration is expensive. So it's not that it's costless. And if we're talking about allocating resources to community, we need to do that. But we need to also think about what we're spending on incarceration. But yeah, no, I think it gets at your question. There's lots of layers to it, but it gets at a lot of the issues around the challenges of kind of seeing this as an isolated issue. Mm-hmm.
Thanks.
Lisa.
Hi, Deb. Nice to see you.
Nice to see you.
Thanks for your talk. I wanted to take you back to the discussion about bail. And as you say, quite rightly, there's been a requirement in at least some cases that you show sort of individual enhanced vulnerability to COVID, right? Because of some underlying medical condition. I don't know if it's happened in BC, but in Ontario, I think, there's lots of cases, but I've read some of them. There's a bit of a split, and some judges, right? Yeah, Justice Copeland in this case called JS.
Yep.
He says when it comes to tertiary ground detention, you don't need to show that individual vulnerability. It's simply the pandemic simply pushes in the direction of release. And then other judges are being sticklers, and certainly on the secondary ground, right? They say you need lots of enhanced individual vulnerability, and maybe that makes sense for secondary ground cases. In those cases, some accused are arguing, hey, listen, I'm so scared of COVID that I'm not going to reoffend. So my risk of reoffending has gone way down. I'm scared because I have asthma or something, right? So logically, I guess that makes sense. But I just wanted to get your thoughts on, what you think of this notion that you have to show that you're particularly susceptible to COVID in order to have that push in the direction of release. And I mean, I'm kind of feeding you the question, right? Because I feel like, the notion that pretrial detention is acceptable, right? Absent some risk of becoming seriously ill or dying. So we know we were very worried about pretrial detention before the pandemic, right? And this notion that, and then of course, and I also just I've been celebrating this decision of Justice Pomerantz in a case called Hearns. Yeah, where she says, absolutely, the management issues that you've described in your talk, canceling visits, lockdowns, all of that, that this is a systemic impact on conditions. The Supreme Court of Canada has told us we can factor in collateral consequences when it comes to thinking about the fitness of sentence. I don't see that the Ontario Court of Appeal has said you can't do that or has said anything contrary to Hearns. They've basically been kind of stingy when it comes to bail pending appeal.
Yeah, those are mostly bail pending appeal cases, aren't they? Yeah.
And that maybe makes a little bit of sense too, given that your presumption of innocence is a little weakened. But I actually think what Justice Pomerantz has done in Hearns is what we should all be citing in sentencing and bail cases, and JS as well.
Yeah, no, I wholeheartedly agree. I don't disagree with anything there, and I think this is the thing about bail. Anyway, we are now reckoning with, before COVID, reckoning with the extent to which bail is so unevenly granted. The law of bail is so unevenly applied across the country, right? There's the local approaches and conditions and culture around bail is so is so varied across the country, and so then when you get and then you have layered on top of that, and so whether sureties are required or whether what the culture is around all those kinds of things. But there's also this other question here around how close are we adhering, in my view, to the presumption that people should be released, right? The presumption that that generally that people should be in the community. Obviously there's reverse onus and all that, but what I'm talking about is this idea that people should be released without conditions, and our law of bail has actually got so I think localized, specific, and cultural issues have developed around it, and there's still a way in which we're just well, should this be someone inside, or should this detained or not? And I feel like we've a bit lost sight of that, and I feel like decisions like Justice Copeland's take us back to that tertiary ground, and what it to the extent that it does any work, this would be a prime case for me to like, I just don't understand why it wouldn't be in every case. But no, you're definitely seeing different approaches. You're seeing that split. I've seen those Ontario cases, and Hearns, I will go back and read it again. I did take a look at it, but I think Justice Pomerantz, there's rarely been a decision that I haven't thought is very thoughtful and kind of on point and providing guidance for the court. So I'll take another look at that and think about what the implications are for the appeal side that Chris was talking about too. Yeah, maybe writing something about that. You should write something about that if you aren't already. You're on mat leave though. You're on mat leave. Sorry, I forgot. Lovely that you're even here.
But I did write something on it, and it'll be in the criminal reports on this bail discussion.
Oh, great. Okay. Can't wait to read it.
Great. Okay. Erica, I see your hand is up.
Hi. Professor Parks, I don't know if you remember, I have a class with you actually in penal policy.
Yes, I recognize you. Hi.
Hi. So I guess that my question is that what role is there to be played between coordination between like local governments, provincial government, federal government, the CSCs, the local courts? Like, what are the issues there? I feel like if there was more coordination between funding programs and sources to be able to control risk and make everybody feel like be able to control that safety issue that we're worried about, whether or not that those kind of coordinations should be happening and aren't, or whether there's issues of jurisdiction that are in there. And I was wondering if you could maybe, if there was anything that, I don't know, if there's about there being more coordination there.
You know what? That's a great question. And there's two places that you could talk about coordination. One is just, at a systemic level, at a systems level, at an organizational level. Okay, we're dealing with COVID. There's certainly, I don't suggest that governments are doing nothing, but what are the attempts to put in place options for release, support for programs. So for example, the Nova Scotia one that I just talked about, where they had 3 months worth of funding for support for folks who were released on that kind of unprecedented 41% reduction in incarcerated people in Nova Scotia. They had 3 months of funding that they were able to kind of wrangle from the provincial government, from one source. I can't remember if it was like Law Foundation or something. And then now they're going to the provincial government asking them to support it. And as I just saw a news story recently, they don't know there's nobody who they get pushed from one ministry to the other, health and justice, and they're trying to get it supported, but so far it hasn't. And it's like I think it cost $61,000, either for a year or for the 3 months. Like, it was not an expensive program, but there's a way in which when you're talking about doing something outside of what's required, like right now, and this goes before pandemic times too, but the criminal legal system and incarceration is always there. It is not going away. Like, it doesn't get, it's always going to be funded. I would wish we could think about defunding it in a whole bunch of ways. But I mean, just like, generally speaking, it's seen as this thing that it's just there. And so you'll go through that system and then you'll be put somewhere. If we want to do something different because we think that's not working and that's actually dangerous for public safety, we have to get ahead of that and actually do and put something new in place. And it just requires political will. It requires folks in the community working together, and it requires, concerted efforts. And there's no kind of magic to it. But I think where you do see it happening, I think you see good, better results. And we need to figure out how we can scale that up in a whole bunch of ways.
Thank you.
Okay, thank you. Dwight, I see your hands up.
Hi, Dwight.
Hi, good to see you.
Lovely to see you too.
Yeah. So obviously none of us wants to deal with anything like COVID ever again in our lifetimes. But supposing we did have a future pandemic at some point, maybe it's too early to think about this right now, too depressing to think about it. But are there things that can be learned in terms of the form of something that could be put in the statute ahead of time, so that there could be a more orderly, well-designed process for release of prisoners in the context of a a future pandemic with similar kinds of risks that arise and so on. And I just wonder, is that something you might work on at some stage as we get through this?
You know, yeah, thanks for that. It's not something I've turned my mind to specifically as to legislation, and it's interesting because it may be that it would be useful to amend the CCRA or the parole provisions or the provisions with respect to incarceration and principles and that sort of thing in the CCRA, and I'd have to think about what that would look like. But I guess my reluctance to go there as the answer is the fact that, going back to what Justice Arbour said in 1996 when she was reviewing the certain events at the Prison for Women in Kingston where women were strip searched illegally by male emergency response team, placed in segregation illegally, again, contrary to the statute, contrary to law. And there was no absence of law, right? And rules. And she said, prison rules are everywhere, but the rule of law is nowhere. That's paraphrasing. And so sometimes, yes, sometimes we need the legislative, like I don't disagree that we want to have good legislation that provides us ways so we don't have to be running off to court and calling it habeas corpus and like creating new law every time. But there actually are provisions, like parole by exception. I mean, maybe we don't want to use that, but UTAs, there's actually really quite reasonably well suited with respect to TAs in particular that could be used. But I do think it's worth contemplating and getting smarter minds than mine, can think about the implications and what kind of a specific legal regime might be useful to facilitate, an audit, for example, of prisoners to require that, for example, if a pandemic is, declared or something, that you have to then do this kind of audit, expedite in this way, invoke this procedure. That could be useful. But I don't think it's the answer because, again, like I said, the law doesn't enforce itself in this context. That's my experience looking at this stuff for the last 20 years.
All right, thank you. Any final questions? Going once. Okay, well, if that's it, that's it. Well, thank you so much, Professor Parks, for that presentation. Thank you to everyone for the really great questions, really insightful discussion. I appreciate you all coming as we approach the new school year and as the summer wraps up. So thank you for your time. And again, thank you, Professor Parks, for spending this hour or so with us. We really do appreciate it.
Well, thank you very much, everyone. It's been great, and you've given me lots to think about too. And if anyone wants to follow up, if questions or thoughts occur later, you can always drop me an email. I'm easy to find on the UBC Allard School of Law website.
Perfect.
Thanks, everyone.
Thank you, everyone. And if you want more information about the Runnymede Society, just type in www.runnymedesociety.ca and you can find out more information about us there. So thank you very much and have a good rest of the day, everyone.
Okay. Bye, everyone.
Thank you. Bye-bye now.